All right, Senate Judiciary will come to order. Pierre, please call the roll.
Senator Kriegel?
Here.
Senator Crum?
Here.
Senator Hicks? Here. Senator Kolb?
Present.
Chairman Olson?
Excused.
You have a quorum.
All right, thanks, Pierre. So first bill we're going to hear today is House Bill 289. Representative Geringer.
Thank you, Mr. Chairman. Rob Geringer, representative for House District 42, which is Southwest Laramie County, here to present today. This is a simple little repealer bill that walks back the Certificate of Need requirements. Certificate of Need laws were first implemented in the United States in the 1960s as a way to control healthcare costs and really ensure the equitable distribution of medical facilities. The idea behind the laws was to prevent unnecessary duplication of healthcare services, which could lead to overinvestment in medical facilities and higher costs for patients. Congress passed an act in the 70s which mandated that all states establish CON programs as a condition for receiving federal funding for healthcare infrastructure. Wyoming responded and did so. However, in 1987, the federal government repealed its own CON requirements, recognizing that these laws had failed to control costs and instead had stifled competition and limited access to care. Since then, many states have followed suit and rolled back their laws to allow healthcare providers to expand and innovate freely. So today, Wyoming remains one of the last states with a CON law restricting nursing home expansion. This bill addresses the issue by repealing those restrictions, which in turn allows for much needed growth in long-term care facilities. So this repeal will increase access to to care by making it easier to expand facilities and add nursing home beds. It'll encourage competition to improve services and affordability, reduce bureaucratic delays that prevent providers from responding quickly to community needs. And as Wyoming population ages, we can adapt by ensuring we have enough capacity to care for our seniors. This bill does not remove safety oversight. The Department of Health will still review facility alterations for health and life safety compliance. It simply ensures that investment decisions are driven by patient needs, not outdated government restrictions. This bill's enactment date in 2026 was intentionally set to give existing facilities time to update, adjust, and plan for expansion. Additionally, by 2029, the Department of Health will report back on the effects of the repeal, ensuring that we track its impact on Wyoming's healthcare system. So really, I guess I'd say that this bill allows us to join the majority of states that have already repealed these unnecessary barriers and allow Wyoming's long-term care industry to grow and better serve our citizens. So I urge you to support this bill, and I'd stand for questions, and if I can't answer them, I know we've got some additional experience in the audience.
Committee, any questions for the sponsor? Senator Hicks.
Mr. Chairman, it's just more of a technical cleanup question, but in existing statutes on page 2, in subsection A, it refers to the division. But yet, in the title, we're talking about the department. And so it's a Department of Health. And in the statutes, it says division. And do we need to just ask the sponsor, is that something that we ought to just clean that up to make clear it's the Department of Health and not the division?
Representative Geringer.
Mr. Chairman, thank you. I'm open to that as an amendment.
Any additional questions for the sponsor? All right, if not, I'd love to hear from our agencies that may or may not be in the room.
Good afternoon, Mr. Chairman, members of the committee. Stephen Johansson, Director for the Wyoming Department of Health. Representative Geringer did a good job with the overview of the bill, made my job easy, so not too much to add. Mostly here as a resource to the committee. Just some brief comments though. The Certificate of Need requirements in statute, we enforce through our Office of Healthcare Licensing and Surveys. That's the office that does everything with state licensure of healthcare facilities, construction plan reviews, those types of things, as well as on the federal side, we ensure compliance with conditions of participation for Medicare and Medicaid. Certificate of need is strictly on the state side of that type of work. And so same office, but very different than enforcing federal provisions. And as Representative Geringer mentioned, the certificate of need laws that were on the federal books did expire or were withdrawn in the late 80s. But many states, I think right now, 30, 35 states have some sort of certificate of need on the books, not just for long-term care facilities, but a peppering of others as well. Really just depends on the state that's in question of where you'll see certificate of need. If it's helpful for the committee, I thought a little bit of data might be useful as you make this decision, and as we testified at other committees who were hearing this bill as well, could shine a little bit of light on how this is used and how we would report on it. Since 2009, about 15 years of data, we've received 18 requests for new construction in nursing facilities. 11 of those were approved, 7 of them were denied. And the natural question there is why would they be denied? Well, in the statute, as you can read if you reference what's being repealed, we enforce certificate of need that the legislature put on the books by looking at a 30-mile radius for any facility that's proposing new construction. And we have to determine per the law, is the average occupancy in that 30-mile radius for nursing facilities greater than or less than 85%. If less than 85%, we have to deny a new construction. If greater than 85%, we can approve that new construction. And then there's some additional flexibilities within the statute where a facility can expand by 10 beds or 10%, depending on what's being proposed. For expansion, so a current facility that would be proposing to expand their number of beds, since 2009, we've received 2 requests for expansion. Both were approved, but only one ended up expanding their number of beds. For what it's worth, again, helpful for me as a data nerd, right now our statewide average occupancy in nursing facilities is approximately 68%, so quite low. A lot of that is still leftover impacts and effects from the pandemic. We did see a quite significant reduction in nursing home occupancy due to deaths from the pandemic, but also because folks, I think, were reluctant to go into long-term care facilities. Generally speaking, people prefer to receive long-term care services in their home if they're available. But we did see some pandemic effects on the nursing home industry for sure. Currently in the state, we have 2 facilities right now that are over 85% occupancy. And that's out of roughly, get you the exact number, but we have roughly 30 nursing homes around the state. So again, Mr. Chairman, members of the committee, we don't have a position on this bill. I think there's pros and cons to all models. We try to effectuate and enforce compliance with what's been on the books with the certificate of need law here to the best of our ability. If it were repealed, we have no issues with the mechanisms in the bill to report back to committees. We don't have to wait till 2029 to do that, but would just caution you, it's difficult in these types of situations to fully quantify the effects of a repealer like this. It's hard to say and look into a crystal ball what new market entrants would look like, investment in long-term care, given Wyoming's natural barriers to entry with a low population, high cost of staff. So it's hard for me as your health director to tell you if this is repealed, what exactly happens. Will you see a lot of new investment or new construction or expansion? It's hard to say. I can say in closing that over the years, there have been some difficult circumstances where a facility wants to expand, but because of the certificate of need law, we're unable to. Some of those facilities I think you could classify as high quality or at least high demand, popular facilities that were restricted in their expansion by that. And 2 interim committees looked at this lightly over the last 2 years. Some discussion about other options with certificate of need and how you could impose quality provisions in there or demand signals in there. But again, you've seen some states that have gone full repeal, some that have not. And like I said, there's pros and cons to both models. With that, Mr. Chairman, happy to answer any questions that the committee has.
Committee, any questions for the director? Senator Kolb?
Yeah, thank you, Mr. Chairman. Director Johansson, do you have any numbers on the cost differential between facility care and in-home care? Thank you, Mr. Chairman.
Director?
Chairman Crago, Senator Kolb, it's a really good question. We do have a report, I'm happy to share that with you, where we look at nursing home cost reports that are submitted to the federal government. We do consolidate those metrics, compare them to their national peers on various financial metrics, days cash on hand, total margin, those types of things that can be useful in an impressionistic sense. Cost structure in a long-term care facility really depends on the business model of that long-term care facility. You have some that are more heavily focused on rehabilitation, which is typically Medicare focused, federal Medicare, for short stays or shorter stays to rehab a patient after a fall or after a hospitalization. You also have a business model centered more around custodial care, where my department's Medicaid program is really the primary payer for that. So it's a mixed bag across the state in terms of cost structure. Those that are focused more on rehab have a higher cost structure because of the nursing and physical therapy, occupational therapy that goes into that. So it's a really terrible answer to your question, Senator Kolb. It's a mixed bag, but happy to share that report where you can get a sense of kind of the finances of our nursing homes around the state.
Anything else, committee? One follow-up, and you may have touched on this a little bit earlier, but Senator Hicks asked the question about the word or definition of division within the statute. Do we need to change that? Should we change that? Could you help us with that?
Mr. Chairman, I don't think it's a need to change that. This goes back decades in statutes where at the time certificate of need laws were being put in place federally and certainly in Wyoming. My department was called the Department of Charities and Reform. There's been a lot of reorganization since then, most notably in the 1990s where the aging department was folded into the department, what was then called the Department of Health, to be the aging division. And so that's just kind of memorialized historically in statute. This Office of Healthcare Licensing and Survey is in a division of my department, so I don't see a conflict there, but certainly up to the legislature if a cleanup is necessary.
Yeah, I would just note that in a lot of this surrounding sections around 906, the word division is used in all of those, so it might get a little more complicated if we change it only in one. But anyways, thank you for that. Any other agency testimony? I don't see anybody else. We'll open up public comment. If anybody wants to come forward before we go to online. Welcome. It's good to see you again.
Thank you, Mr. Chairman. Ben Hornock from Laramie County here, just a concerned citizen. Want to testify about this bill. So I was in the interim committee when we did study this in pretty good detail. And when we studied this, it was one of those issues that we dealt with where a light went on in my head. And I thought that this was a really important thing for the state of Wyoming. And I just want to kind of present that to you and talk about how important this bill is. We do have an aging population in the state of Wyoming. And then we do have private industries that are blocked by our state because of just numbers from expanding and helping out some of those aging populations. So that's what we're up against. And the interesting thing, if you look at some of these repealers, also I want to of note is that our own agency, our own health department things, they are actually exempt from these certificate of need concepts. So it only applies to our private industry. So it kind of blocks our private industry. So I emailed about 11:30 and sent something over that just kind of, you can choose or not, but one of the changes that I would suggest with this bill is just in some of the timing, because of some of the timing factors. So the bill goes into effect roughly a year and a half from now. which kind of is quite a ways out. It gives these businesses a time to kind of look into this and see if they want to do something. But then 3 years from that period of time, there is what I read to be kind of a subjective report required back to the Labor Health Committee. And I'd say subjective, and I want to take away the subjectivity of that, because that's the ultimate goal. And the reason is, I've been in construction for 30 years. I've built, I've been a part of projects that you all would know the name of. So these projects take time to build, and something like this would require a private company to go out and get investments, to get bonding, to get loans, to buy property, to rezone the property, to go through the permitting process for all of that. So that process can take a long time. That process can take a year or more. Then you go out and you get an architect to design these facilities. And even if it's a small expansion on a facility, that design time period can take quite a bit of time to do, working with the owners and making sure they're getting what they want to get with this. And then you go ahead and get your contractor on board, and the contractor builds things. So I'm going to say that it's possible that you could get to a point 5 years from now, and there would not be a single upgraded bed, an additional bed, because of the certificate of need repeal, just because of how long it takes some of these processes with construction to happen. So at that point in time, if you're required to get a report put together, and the report says that not a single bed has been increased, not a single bed capacity has been increased in the state of Wyoming, it's going to look like this didn't matter. But I think you're only going to see the effects of this bill in 5 years, 10 years, 20 years from now. And like I said, we have an aging population. I think this is a really important bill for where Wyoming's going in the future. And so that's kind of why I suggested, rather than to just strike the language that on page 2, the bottom of page 2, that says the report is to state things about the hospitals and nursing care facilities, whether or not that's a positive or negative effect on them. Just to strike that language and have a factual report of what's going on in the construction, how many beds they're proposing, what's happening with the construction process of what's going on. So anyway, that's just wanted to bring that up. Thank you for your time. Thanks for looking into this too. I think it's actually a very important piece of legislation for the state of Wyoming. I'm happy to answer any questions if you have any.
Thank you for being here today. Any questions from the committee? All right, seeing none. Any additional public comment from the room? All right, Pierre, let's.
Mr. Chairman, could I have the sponsor come back up and maybe the director? I want to talk about the effective date.
Absolutely. Director, could you come back up? Oh, and we have one more public comment. We'll let our public comment go, and then Director, if you'd come up, Senator Hicks has a question about the effective date for you and the sponsor, and we can have that conversation in a minute. Ms. Passano, please introduce yourself and tell us.
Good morning.
We need to-
My name is Carolyn Passano. I'm the Executive Director for the Wyoming Healthcare Association, which is a very small association of nursing homes in the state. And we, of course, as you know, have tried to keep the certificate of need, and can see that there is a large voice saying that it really is time to undo it. I know that A&I is saying that we're going to have the elderly numbers growing in the near future. And would just like to let you know that we have tried very hard to get enough workforce And that has been one of the issues that we have worked with and not been very successful over the time. And I actually, when we were really in worse trouble than we are now, we had just lost any foreign workers that were professional and could be brought in. The federal government kind of closed that door on us. And we were unable to, as a state with a small population, replace those numbers. I have talked with the associations themselves and have suggested that they allow me to bring in a robot and show them that a robot could actually deliver meals or medications, some way to alleviate that workforce issue. And that's something that I think we all have to be cognizant of right now, that if we opened it up and if a shiny new building looked wonderful, it could draw off all of the people that would like to work in a building like that. And we might end up with only, in some buildings, Medicaid, which does not pay its way at all, very far from it. So we have to be careful on what we're doing. And I appreciate the fact that there is a time lag in when this would actually get started. I had hoped that we might be doing this a year from now, and that the Washington, D.C. Folks would allow us to bring in foreign workers who are well-trained and would be acceptable in a nursing home. That hasn't happened yet, and so I'm thinking that we're just a year ahead, but the lag in the bill is going to be helpful. I thank you for having this opportunity to speak with you in regard to what the problem is for the internal workings. And I would also throw out that perhaps as we get started with this, that we would have the opportunity to take a look at what robots might do. Foreign countries, be it France or Spain or Japan, are all using robots in nursing homes and have for years. So it's well tested, and perhaps that is one of the things that we can do to help ourselves. Thank you.
Thank you for being here today. Any questions from the committee? All right. Thank you, Ms. Passano. All right, Senator Hicks,
Yeah.
fire away at these gentlemen.
Mr. Chairman and Representative Geringer, you may have talked to it and I just missed it. But why is the effective date all the way out to July 1st of 2026? If it's just a repealer and adding, it seems like this is not a big duty on the department, and I'm just curious as to why we've moved it out so far.
Representative.
Mr. Chairman, Senator Hicks, thanks for that question. It's actually been a point of discussion in previous versions of the bill that maybe the existing facilities needed a little bit of time to make some improvements and come up to speed and give them a little bit more of a leg up when coming to potentially facing some additional facilities being built, so that they could update and get their facilities in even better shape. And so it was kind of a nod to some previous discussion that had occurred on that topic. It originally, in a couple of versions of the bill last year and whatnot, the effective date was same year, and that's why we extended it out an additional year on this particular bill.
So
Follow up?
Mr. Chairman, doesn't that kind of fly in the face of the private sector and competition and, people that maybe should have been doing this already, but now we're saying, well, we're going to kind of let you grandfather in to get in front of the line. And Just would be curious as to your thoughts on that, as it's kind of fencing new people or other facilities that may be interested out.
Representative.
Mr. Chairman, Senator Hicks, I won't disagree with you on that. But it was something that, as we face any particular topic and there's differing viewpoints on the bill and you're trying to come to something that may work a little bit better, that was kind of a concession that was made, I think.
So, Mr. Chair.
Follow up?
So follow up with the director. So, kind of along that same line, so what impact do you see if we change that to, say, July 1st of 2025? What, from your perspective, what impact does that change being that 1-year differential?
Director.
Chairman Crago, Senator Hicks, two ways I'll answer that. One, for the department, there's really no impact. Whether this is repealed effective July 1st of this year or the following year, it doesn't change what we would do, which is essentially stop enforcing the certificate of need. Those requests would not need to be made to the department to expand or construct new. We're agnostic on that. To your broader question of what does it do more system-wide to the nursing home or long-term care industry, I think Representative Geringer said it eloquently, that you do have an existing infrastructure of both private and publicly funded, county-owned, memorial, et cetera, nursing homes that have existed for some time. Would be a delay to both for those types of facilities and potential new entrants to plan for capital construction, those types of things. So industry-wide, again, it's kind of hard to say. As I mentioned before, I can't predict what kind of market entrants new we would see, or even the penchant for current facilities to expand. I think it will be a mixed bag based on the demand in their communities. But again, on the department's perspective, we're completely agnostic on the date.
All right, thank you.
Senator Crum.
Mr. Chairman, just to follow up a little bit on that, the reason the year was pushed back, Representative Geringer said it, perfectly, but it was also working with the industry and trying to say, hey, some of them felt, maybe during this time we can upgrade our facilities, do some things to modernize them where we can, compete and so it was trying to listen to our former legislator, and who just spoke on, workforce and that type of thing, trying to allow a year there for them to modernize and get ready for the competition that was about to come, but yet let them know that we appreciate what they've done for us over the past many years in the long-term care industry.
Any additional questions for the director and the sponsor? Senator Kolb.
Yeah, thank you, Mr. Chairman. I don't know who wants to take this, but could someone explain to me or defend the position of going to the 29 as opposed to going to July of 25? I don't understand, and maybe you could help me with this, is why it's beneficial to do this. I mean, we're making the argument that you're allowing people to change. Okay, fine. But I don't know is very effective in a world of business. If you haven't done it or you don't want to do it, why would you do it unless there's a law change? I mean, I just don't see, I guess I get the part you're being amenable towards existing facilities. I understand that, but putting off the inevitable doesn't change the inevitable. And that's my question is putting off the inevitable, why is it better to do it this way? I mean, I don't know. I can't see it business-wise. I can't see justification. I mean, except I know people in government will wait as long as possible. It's like filing your tax returns. You'll wait as long as possible before you do anything. And I just wondered if that's really in our best interest. That's my question, and maybe it's been redundant, but I'm having troubles understanding why I should go along with that date. I need more help. Thank you, Mr. Chairman.
Senator Kolb, because I'm a little confused, are you talking about the effective date? Or are you talking, because you said 2029, which is the report date. All right, so with that clarification, Representative.
Thank you, Mr. Chairman. Senator Kolb, you make good points. I won't disagree with you. It could just be putting off the inevitable. And it could very well be that existing facilities don't make any updates. It really was just being amenable to some of the concerns that were out there.
In some worlds, we call that a compromise. All right. Any additional, Senator Hicks?
Chairman, in other worlds, they call it capitulation.
Fair enough. All right. Any other testimony from the room? All right, let's go online. Pierre, with Mr. Cook. Yes, please.
Mr. Chair, can you hear me?
We can, but we can't see you.
Let's see how I start my video. I'm not all that handsome, but there you go.
We're glad to see you, Mr. Cook. Please introduce yourself, tell us who you're with, and tell us what we need to know. Thank you.
Yes, sir. I'm Dennis Cook. I'm actually appearing as a concerned citizen with quite a bit of knowledge about healthcare in our community. I'm currently a member of our hospital board of trustees, and I've done that for a while. I sent all of you an email last evening explaining all that. But I'm a Laramie attorney. I've been practicing estate planning and dealing with old people issues for a long time, up to the point where I'm one of them. But I think when I started looking at this issue, the thing that surprised me the most, and this was half a dozen years ago when I said we need to do something about our nursing home, that's when I learned that we had a law that prevented anyone from opening a new nursing home. And I was surprised as a private businessman that government would interfere with the operation of free enterprise in that regard. I appreciated the history lesson from Representative Geringer about how this all started with federal government regulations that had all kinds of good intentions about saving money. And they came to the realization that I think now the sponsors of this bill have come to, that nothing good comes from stifling free business enterprise and competition. So that's why they repealed all the federal requirements, and I think you should repeal the state requirement. Competition is the heart of business. So in my business, and when Senator Crum was a banker, your business is for all of you. You succeed because you provide a product, a good product that's well received by your constituency. There's nothing preventing nursing homes, existing ones, from upgrading their game. But without the repeal of this certificate of need statute, there's no incentive at all for them to up their game on this and provide better care. And that's the whole issue. My experience with our hospital is because it's competitive in the hospital business, we've spent a lot of money being competitive, and that's improved the healthcare in Laramie, Wyoming tremendously with the additional services, better equipment, better facilities. And it's all driven by free enterprise and competition. And that'll happen the minute you repeal this law. It may take, as one of the earlier speakers said, it may take a couple, 3 years for the process to get moving to construct something new. But it will happen, and there will be better care. Places in Colorado where clients of mine go, or even up Senator Craigo, I believe you're from up in the Sheridan area. They have really superior services, and I've had clients move up there just because the service was better that they would receive. So anyway, I support the passage of this bill. I don't want to belabor it. I don't see any particular good reason to wait 1 year or 2 years or whatever period of time. Nothing has stood in the way of any existing facilities to do the right thing to provide better services. So with that, I'll entertain any questions for a stupid old lawyer from Laramie.
All right, Mr. Cook, I think Senator Hicks has a question for you.
Yeah, Mr. Cook is an expert. I wouldn't classify it's because it's spawned a question in me based on your expert testimony. And so when I look at this thing, we've repealed everything in 35-906 except for subsection A, which now we just added the new language in there. But what would be the net effect of just repealing that section also?
Well, let me have a look, see. I've got it up in front of me here. Well, that applies to, building hospitals and surgery centers. And I think there's some benefit, and the director would probably say that, in submitting plans to ensure that the facilities are doing the right thing. So when we've added facilities at our hospital in Laramie, I mean, the architects are experts in what they do, but they also then send it over to the Department of Health to make sure that they're comfortable that we're complying with ADA and all of the other requirements. And so I don't have any particular objection to having some safety oversight in that regard.
Thank you.
Any additional questions for Mr. Cook? All right, seeing none, thank you, Mr. Cook, for being with us today. Appreciate your help on this particular issue.
Thank you, sir.
Pierre, we have no one else on this particular bill. No one else in the room. Going once, going twice. All right, we will close public testimony on House Bill 289. Committee, what's your pleasure? All right, moved by everybody. All right. Do we have any proposed amendments to the bill or discussion on the bill? Yes, sir. Senator Hicks.
Delete 2026 and insert July 1st, 2025.
Okay, any discussion on the amendment? All right, all those in favor, please say aye.
Aye.
Opposed? No, that would be me. That amendment passes. All right, question being called. Any additional discussion? Seeing none, Pierre, please call the roll.
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Cole,
Aye.
and Chairman Olson left an absentee vote of aye. 5 ayes do pass with amendments.
Thank you, Pierre. All right, our next bill is House Bill 111. Representative Smith, Senator Steinmetz. Representative, assume you're going to present the bill?
Yes, thank you.
All right.
Thank you, Mr. Chairman and committee. Before you, you have House Bill number 111, and it is hit and run responsibilities and penalties. In essence, it is an act relating to motor vehicles, increasing penalties for failing to stop where an accident involves serious bodily injury or death, and adding a knowledge requirement for specified failing to stop offenses. So currently in our state law, there is a gap in if you hit somebody, a pedestrian or that kind of thing with your vehicle and you don't stop, there's not very many consequences. And so we're just upping the option for law enforcement and our district attorneys to prosecute people who run off after knowingly. On page 2, line 1, one of the main things that we did add is the word knowingly. And in one of the communities in my district, specifically Torrington here, since 2021, we have had 3 hit-and-run cases, one in 21, one in 22, and here recently, just a week ago, where pedestrians were struck by a motor vehicle and the drivers all ran off. The 21 and 22 incident, the drivers knowingly hit the pedestrians because if you, fortunately, for the detective work of our wonderful police department, they captured everything on video. As horrible and gruesome as that was, they were able to catch the people that hit and run. But when somebody knowingly goes up on the hood of your car, breaks your windshield, and you have to slam on your brakes, swerve, that kind of thing to get the pedestrian off, there's a knowledge issue there, which would be different if someone's standing at a crosswalk and a semi-truck's turning a corner and the semi-driver does not knowingly hit a pedestrian. So the main issue or the big changes are found on page 2, lines 22 and 16. It gives the option for misdemeanor, and then line 22 is a felony. And so it just gives our local law enforcement more room to work. And so that is, in essence, the summary of the bill.
Committee, questions for the sponsor? Senator Hicks.
Yeah, Mr. Chairman, I understand where the intent is, but I've got a couple of questions on this because it looks to me like you give an affirmative defense to somebody that may be in a traffic accident. And let's just say that I go by and your car's sitting on the shoulder and I go by and clip the mirror and hit it just significant enough that it does actually cause bodily injury, but I didn't knowingly know, because the way this is structured, it says, who is knowingly involved in an accident that results in bodily injury. So I have to know that that accident resulted in bodily injury. That's the way this is read. That's the plain reading of the language. A driver of any vehicle who is knowingly involved in an accident that results in bodily injury. I know that I created bodily injury. That's the plain reading of the language. That's the way I read it. I'm assuming that's the way most people would read it. Does it create an affirmative defense now in a case that if I don't stop, that I can say, well, I didn't know anybody was actually injured in the vehicle? So that's the question I have on this. This is the plain reading of the bill. How do I know whether somebody was hurt or not?
Representative?
Thank you, Mr. Chairman. That would be up to the law enforcement's assessment of the situation, and it would go before the courts. But as it stands, oftentimes people would have the knowledge requirement, and I think it is something that currently our local law enforcement is willing to prove. In all the different cases that Torrington has had, there has been that the knowledge requirement has been easy to prove. So, but I do have here with me our Torrington Police Chief that stands in strong support of the bill and may be able to also help answer some of the questions to the process and what the local law enforcement goes through, and might bring clarity to that as well.
Any follow-up, Senator Hicks?
Well, I'm waiting to see what the other sponsor and if the police chief wants to weigh in on that discussion.
That'd be fine. Go ahead, Senator Steinmetz. Thank you.
Thank you, Mr. Chairman. Senator Sherry Steinmetz, Senate District 3, and very thankful that our good police chief could make it down today to help us with this bill. I think one of the other things that brings some clarity to what we're doing is if you look up in the bottom of that paragraph on page 2, line 8, the duty to render aid, which is found in 13.5, 1003, or 1103, the duty to give information and render aid. And it talks about the driver of any vehicle involved in an accident resulting in injury or death of any person or damage to any vehicle. So you're talking about if they ran into your car, or any vehicle or other property which is driven or attended by any person shall give his name, address, registration number, all of that. So they still have the duty to render aid and be there when you're talking about the subsection. So that also still applies. And then there's two provisions as well in this where you have bodily injury, which is contained in subsection I on page 2. And then the next higher penalty goes to serious bodily injury in subsection F of the same statute area. And so if that helps provide some clarity, I mean, I think we can obviously discuss knowingly it wasn't involved in the statute before, but I hope that helps bring a little clarity, and then I would defer to our good police chief with his thoughts of on-the-ground experience and the law as well.
Chief, if you want to help us out, that'd be great.
Mr. Chairman and committee, I'll do my best. I'm Matt Johnson. I have the privilege of serving as the chief of police in the amazing town of Torrington, Wyoming. I appreciate you giving us a couple of minutes today to talk about something that has been pretty impactful in our community, and I know it's also been a big hit in other communities across the state. Essentially, what we're asking for your help with is closing a loophole for serious bodily injury, hit and run accidents, or death-involved hit and run accidents in the state of Wyoming. Right now, if you look at the statute, if a driver commits a hit and run that involves serious bodily injury or death, and to be frank, that's usually involving a pedestrian, if they're not intoxicated, if they didn't have intent to cause harm prior to the accident, or if they weren't exhibiting extremely reckless behavior prior to the impact, that person is very likely to only be charged and convicted of a misdemeanor crime. When you look at the extreme indifference to human life that it requires to hit a pedestrian, watch them slide off of your hood, and then drive away, essentially leaving them to die in the roadway in hopes that you'll get off of the accident issue, that doesn't seem appropriate. And having worked with a number of victims and their families in these crimes, they don't generally find that to be a just solution either. We've had 2 of these in our jurisdiction, 3, the most recent is slightly different. Both of them were ladies who were literally out for a walk getting their exercise. They were crossing the street when a driver was making a left turn into them, did not see them, ran them over. In both cases, the lady literally slid off the hood and they drove away. Both of those women experienced severe bodily injuries, incredibly severe bodily injuries, required months and months of rehabilitation. Both of them suffer lifelong impacts from the accidents, and both of them incurred hundreds and hundreds of thousands of dollars in medical bills as a result. We caught both, or not we, but law enforcement caught both drivers, and both drivers were convicted of a misdemeanor crime. We're asking your help to change that. We think that if you're knowingly involved in an accident that later results or later becomes death or serious bodily injury, that should be a felony. If I can speak, Chairman, to Mr. Senator Hicks's discussion.
Please.
Okay. The way that the statute is constructed is intended to reflect that the knowingly is just being involved in the accident. And if you look at the notion of what we would want to do as law enforcement officers, and certainly what prosecutors and judges would want to do, it would be no benefit to our society to try to convict someone of a crime that they did not knowingly commit. That mens rea is very important. And so that's why we structured that way, is that it's knowingly involved in the accident, and that accident involves death or serious bodily injury. So they don't need to know that they've committed death or serious bodily injury. That's not the intent of the statute. That structure was intended for knowing they were involved in the accident, and then that accident does result in death or serious bodily injury.
Questions? Senator Cole.
Yeah, thank you, Mr. Chairman. Well, I'm not an attorney, so I might ask a question that I should have known. So what I'm hearing is you want to make this a felony because apparently you only can be charged under a misdemeanor for such a crime. And your county attorney, I assume, will be the ones putting charges for these actions, not law enforcement. It's the county attorney that puts charges out. That they have no other mechanism within their ability to charge people in crime. So you could literally wipe out somebody like they did in your community. And there's nothing more than a misdemeanor they can do. Is that the understanding of what's going on?
Chief.
Mr. Chairman, Senator Cole, that can happen. That very much can happen. And that was what we talked about with if the driver's not intoxicated, if the driver didn't have prior criminal intent, and the driver didn't exhibit some extreme reckless behavior, that person may very well only qualify for a misdemeanor charge, because that is what our current statute reflects, is if it's a serious death or bodily injury, or if it's death or serious bodily injury, it's only a misdemeanor.
Follow up?
Well, just to ask a dumb question here, how does that get rid of mens rea? I mean, you're now telling me that you don't have to know you did it, so you have no knowledge that you hit somebody. Like, to say you're driving down the road and you don't realize you hit somebody, and you don't have any malice, you're just, I guess, not paying attention. Is that possible to to charge them when they didn't know what they did? I mean, that's from my, I guess, rudimentary understanding about how this would work, to charge somebody. You're going to go to court, and I guess if they didn't have knowledge of what they did, get convicted. I mean, we had a case, there's other cases where people hit people, young people. And they couldn't be charged with vehicular homicide because they had no intent. I mean, they couldn't prove intent. It was poor conduct. It was terrible. It was a tragedy. I'm just trying to get to the fact of, are we going to be able to make this work with the knowingly? And I understand why you put it in there. But it just seems like this is more of a question for the county attorney about being able to charge for this. And maybe that's a question that our legal folks here on this committee can answer.
Chief, answer if you can.
Mr. Chairman, Senator Cole, I believe I understand your question, and what I believe you're asking me is whether or not we could charge someone with a crime for what they did not know they committed. Is that an accurate assessment?
Senator Gold, can help him out.
In that scenario I lined out, yeah.
Okay.
Well, to be clear, Chief, I mean, the county attorney charges people with the crime. Isn't that true or not?
Mr. Chairman?
Chief.
So we make arrests based on probable cause, and then a county attorney would prosecute based on the charges that we bring forward, or they could change the charges. To answer your question, the statute is deliberately constructed to avoid those situations. I'll give you two examples to hopefully illustrate why we constructed it the way that we did. The first is the very easy two that we had in our community, where the driver wasn't intoxicated, they weren't displaying criminal intent to cause the injury, and they did not drive in a super reckless fashion prior to the accident, but they definitely knew that that accident had occurred, and they deliberately left that person for dead and drove away. In that case, we believe that that person should be charged with a felony crime because they displayed an incredible level of disrespect for human life and increased the probability of that person dying on the roadway. The second example would be one from a prior jurisdiction I worked in, where a semi-truck was driving down the interstate and there was a person who was suicidal that dove under the back duals of the semi. It was a 120-pound person and an 85,000-pound semi. That semi-driver had no idea and would have never known that they were involved in an accident. And in my opinion, and I believe in every prosecutor and every judge's opinion, that would not be a case that we need to try to prosecute as a felony, because that person had no knowledge and couldn't have had knowledge that that accident occurred. Does that help to clarify that?
Senator Cole?
Yeah, I'm fine with that. I mean, I'm talking about more nuanced issues. I get it in the extremes. You just gave an example of obviously a no-brainer, right? Well, life isn't that simple. I guess that was what I was trying to drill down on the reality of dealing with situations that aren't so cut and dry. I agree with you. I agree 100% with what you said.
Okay, thank you. I'm sorry, Mr. Chairman.
So I got a question for you, Chief, for either of the sponsors. So is this statute, the current statute, and if we were to pass this law, it doesn't just apply to circumstances where a car runs over a pedestrian. It applies to circumstances where one car runs into another car, correct?
Mr. Chairman, and, oh, darn it, two microphones.
Senator?
Mr. Chairman, so it's under accidents, and this is the duty to stop a vehicle where an accident involves death or personal injury and penalties. So that's the subsection. And then what it does is it creates a second penalty. So when it started out, there was just the misdemeanor penalty. And so this creates, for serious bodily injury, it creates the felony. So that's the big difference, but it says any person shall immediately stop a vehicle at the scene of an accident. So it is a scene of an accident. It's not just a hit and run the way I read it.
So just so we're clear, it does apply, and this might be a rhetorical question, but it does apply in vehicle to vehicle circumstances. We're not just talking about where you run over a pedestrian, correct?
That's the way I read it, Mr. Chairman, but it does bring in 31.5.1103, which is the duty to give aid as well. And so that goes a little further into the hit and run part of it.
Chief, so simple yes or no. I know you've written these tickets before. So.
Mr. Chairman, yes, it would apply to any and all accident that occurred in the state of Wyoming. So any hit and run that involved death or serious bodily injury, or any hit and run that involved injury would apply under the statute.
Thank you. That's helpful. Any other questions for our panel? Senator Crum.
Yeah, completely changing topics almost, but where did the $5,000 and the $50,000 come from? And maybe it's in statute, but we've been dealing with a lot with $1,000 and a couple $1,000 for the penalties. Where did the $5,000 and the $50,000 come from?
Chief.
Mr. Chairman, as we looked at those penalties, we tried to compare them with vehicular homicide and with some of the other severe felony level crimes. And we looked at a balance of where that fit kind of in the middle, for lack of a better way to put that. We tried to have penalties that were not as severe as vehicular homicide, but were more severe than the misdemeanor crime. If you'll forgive me for deviating slightly in explanation, one of the things that we look at is if a person commits a hit and run accident that involves death or serious bodily injury, and they are intoxicated. Right now, it is of a significant advantage to them to go home quickly, leave the scene of the accident, lock their door, not answer it, and allow themselves to either sober up or drink a lot more alcohol so that they can claim that they were not intoxicated during the time that the accident occurred, because that would trigger a felony charge. If that makes sense? And so we were looking for a level of severity that would address appropriately the amount of disrespect for human life, if you would, and also be a motivating and preventing factor for folks to not complete actions such as what I just outlined to you.
Another question. Just because I'm thinking about the broad nature of this particular proposed language. It doesn't assign fault. You don't have to be at fault for the accident, for the felony for you to be caught up in the felony, correct?
Mr. Chairman.
Senator.
The way that I read it, Mr. Chairman, is the assigning fault is part of that is the knowingly. I think that's why they put it in there. I mean, it should be obvious, but in the case of the semi, it wasn't.
Yeah, so let me give you a scenario. I'm thinking I have two young daughters. Let's say one of them's parked at a stop sign and they're driving my big pickup, and someone's driving a really tiny car and they run into the back of my pickup and my daughter's driving, and the person driving the little tiny car breaks their arm, which is a serious bodily injury according to statute. A simple broken bone is serious bodily injury. The driver of the vehicle gets out and says, "Oh, my fault, not your fault. I'm good. I'm gonna go get my arm fixed." And they both drive away. That would be a violation of this proposed statute for both of them, not just my daughter, but for also the person driving the car that broke their own arm. No fault. I mean, my daughter didn't cause the injury. She was just parked at a stop sign. That would be a violation of this as written, correct?
Mr.
Letter of the law, as it's written.
Mr. Chairman, I don't believe so because it brings in 31.5.1103, duty to give information and render aid. And it says that in the event shall remain at the scene of an accident until he has fulfilled the requirements of 31.5.1103. So if they've fulfilled those requirements of exchanging information, attending to the person, carrying out that subsection, I believe they've completed that, and they're not supposed to leave the crime until they complete the duty to give information and render aid. So that's found in 31.5.1103.
Thank you, Senator.
You're welcome.
Any additional question for our good panel from the committee? Senator Cole.
Yeah, thank you, Mr. Chairman. I don't know where this came from, this document. And my question is, on this document, did they all knowingly leave, all these people here? Do we have any data on that? Thank you, Mr. Chairman.
Mr. Chairman?
Representative.
All right, thank you. Senator Kolb, that is for another testimony with the Highway Patrol. So they're going to come up next and testify, and they'll walk you through that.
Okay. I guess we'll have the Highway Patrol come up.
Mr. Chairman, Casey Ramsey, Wyoming Highway Patrol. Just here to let the committee know that Patrol does not have any issues with the way that the bill is worded. In fact, we believe that it goes a long way to deter people from leaving the scene of a crash, serious bodily injury. And as you know, unfortunately, not all the time do we catch those individuals, and there's always a victim as a result of that we don't necessarily get to take care of. I did bring some statistics that were provided to me from our crash records section of the Wyoming Department of Transportation, and this is all crashes dealing with hit and runs for all agencies in the state. And I stand for questions.
Thank you for being here today. Questions from the committee? Senator Hicks.
So, Mr. Chairman, so this is a hypothetical. So when we look at your data here and we go over and you just look at injuries, because this bill now says I have to knowingly create an injury to be guilty of, what's that? So I don't know why that echoes so bad, Mr. Chairman. So when we look at that, it talks about those injuries. And so, we range from 140 to 168. And so with the new language in here, how many of those injuries that happen would you have to document that those individuals knowingly created those injuries for your officers to be able to cite somebody underneath this statute?
Mr. Ramsey.
Mr. Chairman, Senator Hicks, can you repeat your question? I'm trying to understand what you're asking.
So you've shown in your data here that you've had all these injuries every year. So what I'm trying to figure out, these were documented injuries, correct? Do we have any data that knows how many of those were knowingly by another driver created? Because it gets to the very discussion that we're trying to get to. How do you determine which one of these were knowingly created in an accident? And how are you going to cite those? That individually knowingly created those injuries, excuse me.
Answer if you can.
Mr. Chairman, Senator Hicks, I would say that would require me to speculate. I would need to know a little bit more information on each one of those crashes to see. I mean, we obviously know that they were listed in our crash report beam, which is what all officers in the state of Wyoming use on a crash report. So I don't know right now that it captures that information. We are moving to a new crash system. It may capture that information. I can see if our crash record section could drill down more to answer whether or not they were able to determine that knowingly factor. But I think with the previous discussions that you had with the chief there, yeah, I don't know where I'm going with that other than the fact that in most of those cases, you're going to understand that individual did know that they actually hit somebody or ran into somebody and caused a crash. They may not know if there's actually injury at that point in time, but they did know that they were involved in the crash and they chose to leave the scene.
So
Follow up?
see if I can get us to where I'm going. So follow up on that saying, so they know they hit somebody. The clear language of this now states the driver of any vehicle who knowingly involved in an accident that resulted in bodily injury. So they knowingly had to be guilty of this law. Would you agree with that? If they didn't know that they actually had created bodily injury, you wouldn't be able to cite them underneath this statute, or would you? The litmus test here is they knew they created bodily injury. That's what it says.
Trooper Ramsey?
Senator Crago, Chairman Crago, Senator Hicks, the way I read that is that they would knowingly know that they were involved in that accident.
It doesn't say that. Mr. Chairman, if I may.
Senator Hicks?
It is a full, complete sentence. There is no comma, there's no semicolon, there's no break. The sentence means what it says. Any driver in any vehicle who knowingly involved in an accident that results in bodily injury. You can't arbitrarily, in the laws of the state of Wyoming, say, well, there's a comment or a hyphen there, I get to break that sentence. That's my point. The way this is, I agree with everything you're trying to do here. The language creates an affirmative defense for somebody that didn't know anything, because you, as law enforcement or a prosecutor or a judge, can't arbitrarily say, well, I'm stopping in the middle of a sentence. It is a complete sentence and it has meanings, and words mean things when it comes to criminal court. That's what I'm trying to get at. I'm not trying to kill the bill. I'm trying to say, it looks to me like any normal person reads a whole sentence and takes it in context of the whole sentence. I'm just trying to make sure we don't create a loophole here.
Wouldn't you think? Do you have any response
Would you
to that?
disagree with that, or
Trooper
agree?
Ramsey?
Chairman Crago, Senator Hicks, you're absolutely right. We got to read the whole sentence to understand what the full intent of that statute is. And I apologize. I didn't mean to just read to that.
All right, well, I'm trying to help here. So that when you cite somebody, they don't have an affirmative defense because we decided that they were in an accident. So
Yeah.
you understand what I'm trying to get to.
Trooper Ramsey?
Chairman Crago, Senator Hicks, yeah, I agree.
All right.
So can I ask a question for you? I'm separate from the, jurisdiction of the town of Torrington and Goshen County. How often is this a problem? I mean, are we fixing a large issue here statewide, or is this more of a local issue? Can you give us, these statistics don't necessarily help. I know it's statewide numbers, but give us some anecdotal information on, are we going to be helping other law enforcement agencies as well as yours?
Chairman Craig, very good question. Yeah, these stats don't really tell you more than that. If you're looking at the critical crashes and the serious crashes, that's what's occurred throughout the state of Wyoming. I can't tell you how many of them knowingly left the scene of a crash. We just know that they left the scene of a crash. When you're asking the question of, does this help law enforcement throughout the state? Yes, it does. I can think of an incident here recently up in the Thermop area where my agency investigated a hit and run up there, a very serious one that ended up in death. So yes, it will help law enforcement. I can tell you throughout my career, I have had to work several of these where we weren't able to find the person that left the scene of the crash. Most of those involved semi-trucks.
It did. Thank you. Senator?
Thank you for your indulgence, Mr. Chairman. I'm going to try to let these good gentlemen off the hot seat a little bit here. And I was hoping that we could maybe look at that sentence, and we were just visiting in the back. What if we said, Mr. Chairman, the driver of any vehicle who is knowingly involved in an accident, comma, and that accident results in bodily injury, serious bodily injury, or the death of any person, shall immediately stop the vehicle at the scene of the accident. I don't know if that gets to what the good senator is concerned about.
I'm pretty sure he'll tell us.
I'm pretty sure you're right. But I would also say again, as I did when we started this knowingly conversation, which we've had many discussions about the word knowingly over the years on the floor, that was not in statute before. So, you know, and it has been functioning to some degree. That's new language. So it would be the committee's discretion whether that helps or harms this area of statute.
Thank you. Any questions? All right, any additional public testimony in the room? Mr. Thompson?
You can't write a sentence and say, oh, I decided. So it's a structure. It's just a structure.
Hello, Mr. Chairman. My name is Alan Thompson, the Executive Director of Wascop Wyoming Association of Sheriffs and Chiefs of Police. Our membership has discussed this concept quite a bit, anecdotally provided some stories where this has occurred across the state. And I would like to reinforce the example that was given earlier about the DUI and the ability for someone to avoid those more serious charges if they just disappear for an amount of time or otherwise get more intoxicated and indicate that intoxication started after the crash. They would face that. And I do appreciate the consideration today for making this penalty commensurate with the crime. And I would like to repeat the testimony that we heard earlier about trying to capture that deliberate indifference for human life. And if I may offer a concept, I'm not sure the bringer of the bill would agree with this, but if we leave the language exactly as it is in this bill, the driver of any vehicle who is knowingly involved in an accident that results in injury, serious bodily injury, death of another person, and so on, that makes it the burden of proof on the prosecution to prove that that bodily injury was known. So the examples that were given today were when people slide up the hood of a car and crash partially through a windshield and then slide back off the hood of the car, it's very easy for a prosecutor to convince a jury or a judge that that was knowingly. They knew that occurred, and that could likely cause that serious bodily injury, as opposed to clipping a mirror on a main street. And maybe you know that you clipped a mirror on Main Street, but you have no clue whatsoever that that mirror flipped back through an open window and hurt an individual in a vehicle. That doesn't sound like deliberate indifference for human life. That sounds like deliberate indifference for property damage. And I think what I can't speak on, I guess, the bringer of the bill, but I think that those are two different things. And I think that this bill as crafted right now puts the burden of proof onto the prosecution and leaves that felony in the realm of serious bodily injury. And I would answer any questions if you would like to ask any, Mr. Chairman.
Committee, any questions for Mr. Thompson? So seeing none, I'll ask my question really, which goes to the broad nature, because I think we're throwing a really large net out, and I understand what we're trying to get to. I'm worried about the size of the net and whether we're covering too much. So maybe help me with that and why I'm wrong about that.
Yeah, Mr. Chairman, I don't see an application of hit and run right now on those cases where people think they've done what the requirement is. They don't seem to be hiding from it. I think if you're talking about the example of two vehicles involved in a crash and they go their separate ways, right? There's other statutes, when you take this section as a whole, there is a requirement to notify law enforcement if there's damage over $1,000. Not everybody does that, but I don't know law enforcement is writing that ticket for hit and run when it comes to light 5 days later. They're just trying to work a case with the evidence at the scene. I just don't know any indication that that type of incident is being prosecuted, and that's where prosecutorial discretion comes in there. It has to go through an officer filing the charges, a prosecutor officially filing them and following through with those charges, and then a judge or a jury, depending on the thing. So all of those steps work in favor of the defendant. And I think if we look at the spirit of the law, that's not what we're trying to capture here. And we would hope that the system would benefit the person involved in that as it does now without knowingly in the statute.
Any other questions for Mr. Thompson? All right, so I think we need to go online, Pierre. Welcome back, Mr. Chairman. You're back in charge.
No, just keep going. You're good.
All right, Mr. and Mrs. Griffin. You could turn on your camera, tell us who you are.
Turn it on. My name is Andrea Griffin. I live in Torrington. I am one of the cases that Chief Johnson was referring to. On October 26th of 2022, I was crossing in a crosswalk across Highway 2685. I was in a crosswalk. I had pushed the button. There was time on the timer, and I was almost across the highway, almost, when I was blindsided. The man who hit me came from behind me, and I woke up in the middle of the highway with a man cradling my head and shoulders in his knees in the middle of this highway, which is extremely busy, telling me, don't move, you may have injuries to your neck and spine. That was the first moment I knew that something was wrong. I laid in that highway. I was in and out of consciousness. I happened to look up, and there's my brother standing there who had seen something going on. Nobody was stopping traffic. He pulled over to stop traffic and saw me laying in the highway. Now, I'm going to try to make this a little concise. I'm not good at that. I'm pretty wordy. My injuries were significant. I had several skull fractures. The entire left side of my face was fractured. My left orbital socket was fractured. My eye was lacerated. My right wrist, I believe, was broken, but my left wrist was crushed. My left hip was broken, the femur right below the hip itself. I had to be air ambulanced from Torrington to Greeley, where 2 days later I underwent 8 hours of surgery. I spent 3 weeks in the hospital. I spent 4 months in physical and occupational therapy, going 3 times a week for 2 to 2.5 hours a day. I strongly encourage this committee to pass this bill. In my particular case, the expense to my insurance company, to my husband and me, is in the hundreds of thousands of dollars. The man who hit me had no insurance. He also denied hitting me. But in my case, the man who was cradling me in the highway was a school bus driver, a former police officer. And that school bus caught the vehicle on camera. It didn't catch the impact, which I'm thankful for, but they caught this vehicle driving away. He too said he didn't know he had hit me. I'm 6 foot tall. I had a bright red coat on. I went up on his hood. He knew he hit me. It's mind-boggling to me that in the state of Wyoming, that a felony theft of $1,000 is a felony. You steal $1,000, that's a felony in terms of dollars and cents, because that is something that people understand, dollars and cents. They don't identify with the physical and the emotional impact of something like this. I think this is an important bill, if for no other reason, to make people understand all you gotta do is stop. Just stop. If the guy that hit me had stopped, other people wouldn't have been put in danger to try to help me. I would like for this bill to pass for future incidents. I can tell you, when I went and met with the district attorney in my case, and he told me this is a misdemeanor charge, I couldn't believe it. I walked into his office using what we called a contraption.
Miss Griffin?
Yes.
Is Greg going to testify too, or just you?
Just me.
Okay, well, I'll give you another minute or two, and then we better, sorry to interrupt you. We just get back to the floor, and we need time to work the bill, actually.
Sure. I just want this committee to understand the significance of this bill and how it isn't just to help law enforcement, but it is to help judges, prosecutors, to be able to work with the situation at hand. Thank you.
Thank you for being with us today, and sorry you had to go through that. Any questions from the committee? All right, seeing none, thanks for helping us out today, Ms. Griffin. All right, any other testimony? Pierre, nothing else online, nothing else in the room? I'm gonna close public comment. Committee, what is your pleasure?
Move the bill.
Moved by Senator Hicks. Discussion, amendments on the bill?
Mr. Chairman.
Senator Hicks, turn your mic on. It was on.
I've got an amendment to it, but it's complicated enough that I just don't think that we're gonna be able to work this. The concept would be to leave the existing statute in place and then bring in another subsection B that gets to the felony and the knowingly side of that, instead of just casting this broad net. So we would have the existing statute in place is the way it's currently structured, and then bring in a new subsection B down there that brings in the knowingly component for the felony charge. But it's a little, at this point in time, I can't work this in at this point in time, so maybe I can work with the sponsors and we can get that. But I would like to have a little discussion with the committee if that's a direction that they would support, Mr. Chairman.
Senator Olson, Mr. Chairman.
Mr. Chairman, I wasn't here for the testimony on knowingly, but just having read this bill and looking at it now, I think you can drive a semi-truck through this. So I'm not sure how I feel about the bill in total, but if we want a bill that's gonna work, that language is not helpful at all. And you probably only want it to apply to the felony, not the misdemeanor. So I agree with your idea of structuring it different. It would need to be structured very differently. I also think there's a couple of different ways to do it. You could attach the knowingly to the bodily injury. You could attach it to the accident itself. But yeah, I don't have an amendment for it, but I'm tracking what you're tracking.
Any additional discussion on the bill? Senator Kolb.
Yeah, Mr. Chairman, at this point, I guess the question is, do you want to lay it back, or do you try to work it in committee, or push it to the floor and try to amend it out there? That's the question I have. The intent of the bill I agree with. I think the way it's structured is very problematic for me.
Senator Hicks.
Incumbent for us as a committee to ask the sponsors whether they're receptive to putting this out and then working on a committee of the whole amendment, or we lay it back and come back and try to redo the bill. And I think that's just a courtesy to the sponsor to see which direction they'd like to go. But Mr. Chairman, that's just my recommendation.
We can sure get their opinion. Representative Smith.
Mr. Chairman, thank you. I would be amenable to allowing the committee of the whole to work it out and have that amendment that we could work offline and have something we can agree on.
Thank you, Representative.
Thank you.
Any other discussion on the bill?
Mr. Chairman?
Senator Crum.
I'm just thinking here, and we've got a good representative right here. To me, it'd be easier to work here with 5 people than with 31 people. So I guess I'll leave it up to the sponsor, but to me, it's easier to work with 5 than 31 if we're trying to work something. I think we all probably agree, or at least I do, with the intent of it. It's just, how do we make it work? So when these folks do arrest somebody, they can get them.
Senator Olson.
Mr. Chairman, I think you either need to have the amendment now, or you're gonna have to vote on the bill and either send it to the floor, or if it's not ready, then it's not ready. But we don't, we have more bills than any other committee. We don't have the ability to bring this to a second meeting. We're already gonna struggle to get through all of our bills because of how much they've loaded us. So I would say, if you're gonna amend this committee, if you're gonna amend this bill, this is the time to do it. Otherwise, you need to be comfortable with amending it on the floor. I will say, just, my own personal thoughts as a whole, I have pause in this bill, creating a new felony that is a 5-year felony or a $50,000 fine. What was just described to us by Ms. Griffin is absolutely heinous. When something like that happens to someone, their best remedy for them individually is going to be a civil suit where they can try to recover damages for what they went through. Creating a felony isn't going to change that for Ms. Griffin, unfortunately. I understand that there might be an idea that it will change it for someone in the future down the line, but I just don't think that's how hit and runs work. If you're creating it's very different when you compare the theft statute, because when you create a statute that prohibits theft, a person has to think about a criminal penalty before they take something. This is very different. A person is driving down the road. Of course, most people are thinking about how they're driving, but a person's not going to be driving down the road thinking, I can't hit someone. If I do that and I am knowingly involved in an accident and it causes seriously bodily injury, I'm going to go to prison for 5 years. It's not going to deter people, is I guess what I'm getting to. So I have pause on the felony portion of this statute actually doing what we want it to do, Mr. Chairman.
Thank you, Senator. Any further discussion? Senator Hicks?
Yeah, Mr. Chair. I remember, but there is a provision that we could pass it out as do pass fail. I can't remember exactly without having to talk to LSO, the ramifications of doing that.
Senator Olson, I was going to answer, but go ahead.
Yeah, that sends it to automatically places it on the bottom of the majority floor leaders list. So she doesn't have control automatically to move it, but I think she can move it. I don't know if she can move it later or if it just has to stay there.
I don't remember either.
That part I don't remember, but to move it. So if you were to do that, that would give you time to work an amendment for certain. Do we have a motion on the bill?
Senator Olson, we do not. Well, sorry, we have a motion to, we have a do pass, sorry. Yeah, we do, we have a do pass, yes. Senator Hicks, I apologize. So, Senator Kolb.
Yeah, Mr. Chairman, the way this bill's currently written, I can't in good conscience send it out of here. I can't, so I can't vote for it the way it is. It's just, it's too big of a lift, and I feel responsible with anything that I vote for and have to explain that, and I just can't justify this the way it's written.
Any other discussion, committee? If not, we will call the roll.
Senator Craigo,
No.
Senator Crum,
No.
Senator Hicks,
Aye.
Senator Kolb,
No?
Chairman Olson.
No.
1 aye, 4 noes. Do pass failed.